this presentation, we will be discussing the differences in legislation inside the European Union in relation to copyright law, online streaming and downloads, and the access to YouTube videos, using Germany and Spain as examples. As we learned from Van Dijk, intellectual property law is differentiated into three parts. This presentation, we will focus on the economical aspect and the protection of rights through copyright law. First of all, we'll present the existing legislation in the EU, Spain, and Germany. Then, we will move on to the problems occurring around the legislation, and to conclude, we'll present how it is possible that there are differences in legislation inside the European Union. In order to introduce a brief history of copyright law in the EU, we'll now have a look at the Berne Convention for the Protection of Literary and Artistic Works, which was signed in 1886. It required signing states to accept copyrighted works of authors from other signing states in the same manner as they would for their own authors. This convention founded internationalized copyright and thus equal treatment in these aspects. It obliged states to create minimum standards for copyright law. Before the convention was signed, national copyright laws were only valid in the national's country. This means that individuals could use the works of someone else from a different nationality however they wanted to. Both Germany and Spain signed the first version of the convention in 1886. In 1993, the Copyright Duration Directive was created to harmonize the term of protection of copyright and certain related rights. It is a copyright law directive under the internal market provisions of the Treaty of Rome and guarantees a set length for copyright and related rights across the EU. Works are copyrighted for 70 years after the author's death, or in cases of anonymity or pseudonyms, 70 years from the date of the first lawful publication. This directive has been implemented in Germany and Spain, and was replaced in 2006 by a revised and consolidated directive. In terms of online streaming, the Court of Justice of the European Union has ruled that the streaming and viewing of online content, even if it is copyrighted, is legal since the 5th of June 2014. Viewing directly from a web browser, or in other words, streaming from a host website, is legal and does not classify as copyright infringement as long as the user is not making a copy of said content. It is legal, however, for a state to restrict a user's internet access if it is needed. EU member states were given the rights to implement these changes into their own laws.
Well, we are going to talk about some of the problems that can come up in the current situation with different legislations when it comes to enforcing copyright law. Mainly, there are 5 points here to be mentioned. The consumer attitude, the business attitude, the complexity and locality of the issue, and the consumer protection. So first of all, we're going to talk about the consumer attitude. Historically, there has been a disparity nowadays between the creation and the copying of products. So nowadays, the copying of a product, which costs a lot of time and a lot of resources, including financial resources, has gone down to zero. So therefore, the traditional businesses or firms that had a monopoly in the distribution of these products, be it movies or music, has vanished. So basically, everyone can share contents for free. Also, the threshold of intellectual property has gone very low. In the earlier days, it was clear between intellectual property and not intellectual property, because a movie or a tape required certain efforts. But nowadays, since we all have the power to upload images or whatever videos, we are the authors of the content ourselves, therefore are also subject to intellectual property. But moreover, the business's attitude also influences the current conflicts in the copyright law. Right now, the punishments inflicted upon individuals for infringing upon copyright law are effective, but in a collective sense, vain. Because, in fact, most people argue that they do not represent an adequate estimation of the damage that was actually done due to the download. And this also leads to a decreasing relation between the law and the people. So the people feel that the law does not represent what's right anymore, but more represents the interests of the businesses involved, the artists' interests. And lastly, the complexity and locality is a huge issue. Due to the digital nature, it is hard to grasp when something is in fact intellectual property. So, is a picture that I upload intellectual property? Or is a text that I post up on social media, is that intellectual property too? Moreover, there's the issue of the locality of the servers, the locality of the users, and more and more users are using proxy servers, making it even harder to determine upon which legislation is the infringement to be based upon. And also, there's a constant reappearing of, for example, file sharing websites. There was a famous case of a movie sharing website called Kino.to, which just one day later reappeared as KinoX.to.
I will now answer our question, what is it based on? The two European Union countries, Germany and Spain, have differing legislation in relation with copyrights, online streaming and downloads, and the access to YouTube videos. I'll try to clarify this on an example of online file sharing. File sharing means the exchange of data in a so-called peer-to-peer network, which is created through special programs and enables persons to share files by uploading them onto the network and/or downloading them to their personal computer. An example would be to publicly provide an online stream or download option of a movie on a host website such as YouTube. First of all, let's go back to the legislations of Germany and Spain. In Germany, downloads and uploads onto P2P networks are declared illegal. The country has special control bodies monitoring online action that is illegal on platforms such as YouTube. When illegal action was detected, the internet subscriber will be followed by its IP address and will receive a first warning outside of court, which includes a financial compensation request and an order against further usage. In Spain, on the other hand, Judge Paz Aldecoa declared in 2006 file downloading for private use as legal. Despite many troubles weathered by the entertainment industry, especially coming from the United States, file sharing and torrent websites were again ruled legal in Spain in March 2010. The statement of the judge was the following: P2P networks are mere conduits for the transmission of data between internet users, and on this basis they do not infringe rights protected by intellectual property laws. Let me show you this in numbers. According to statistics, 30% of the Spanish population uses file sharing websites. On the contrary, the European average value of file sharing is only at 15%. Could we therefore call Spain the pirates of the Mediterranean? Now we reach the point of answering the question. To conclude, Germany and Spain have a common law situation based on the EU directive, which states downloads are illegal, online streaming, however, is legal. Yet, on national level, Spanish judges are more accommodating than the German ones. The Spanish Supreme Court, for example, has ruled personal data associated with an IP address may only be disclosed in the course of a criminal investigation or for public safety reasons. In Germany, on the other hand, the organization GEMA blocks 60% of the most favored YouTube videos. We can thus conclude there is no direct difference in the existing laws, but a difference in the judiciary decision-making. I will end our presentation with tendencies of changes inside the EU copyright law. The music industry pressures Spain and other countries into stricter changes in their legislation on copyright. Online copyright protection is currently one of the EU's main focuses of intellectual property right based on the difficulties to control online action. Yet, consumers often protest against strict decision-making and can also influence decisions.